Okay, so let's unpack this. We've got a really interesting legal puzzle on our hands today.
Hmm.
It's straight from the 2024 October Zone A exams, question 3, and it's all about proprietary estoppel.
A classic and often tricky area.
Exactly. And for you listening, this is a great chance to get a solid grip on, well, why land law has all these rules, but also where those rules sometimes have to bend a bit, to be fair.
That tension, yeah, between legal certainty and, well, basic justice.
We're diving deep into that push and pull. Our focus today is very much on this specific exam question, looking at why we need formalities in property law.
Things like deeds and written contracts.
Right. And then the exceptions, particularly this tricky one, proprietary estoppel. So our mission, to really understand why it exists, its strengths, and maybe, crucially, its weaknesses.
And it's interesting, the exam question itself really lays it out, doesn't it? It basically says, look, there are good reasons for formalities,
Sensible, valid reasons, yeah.
but there are also good reasons for the exceptions. The kicker, though, is the question suggests these exceptions need to be clearly defined. And then it says, well, that can't really be said for how proprietary estoppel works right now.
Which perfectly sets the stage for what we need to talk about. So let's start with that foundation.
Hmm.
Why all the fuss about written contracts, deeds for land? The exam question points to key reasons. First up, clarity and certainty.
Yeah, that's fundamental. Section 2 of the Law of Property, Miscellaneous Provisions Act, 1989, it insists on written, signed agreements, all terms included.
Why is that so vital, just knowing where you stand?
Well, think about land. It's usually high value, right? Often someone's biggest asset lasts for ages.
Generations, sometimes.
Exactly. So having it all written down from the get-go, like the exam question implies, means everyone involved knows their rights, their obligations. It just cuts down on confusion.
Prevents arguments later about who promised what.
Right. Minimizes ambiguity.
Okay, and beyond just clarity between the people involved now, what about preventing fraud or even just honest mistakes? How do formalities help there?
Well, without something solid in writing, it's just easier for someone to, make up a claim, say they were promised something.
He said, she said.
Pretty much. And memory fades, right? Oral agreements get twisted over time. Formal documents are concrete evidence. Much harder to argue with. It reduces the scope for, well, dodgy dealings and genuine misunderstandings.
Makes perfect sense. And the exam question also mentions publicity and notice. That ties into the Land Registration Act, 2002, making rights visible. What's the benefit of that transparency for, say, future buyers?
Oh, huge benefits. The land register is basically a public database. Tells you who owns what and what other rights affect the land mortgages, rights of way, that sort of thing.
Okay.
So if you're thinking of buying, you can check the title first, know exactly what you're buying into, no nasty surprises.
Protects the buyer.
Definitely. And it just helps the whole property market work more smoothly. Reliable info, easy to access.
And one more point, the question touches on deliberation and caution. Does the actual process, getting lawyers involved, signing deeds, does it make people pause and take it more seriously?
I think it does. It's not like scribbling on a napkin, is it? It's a structured process. You draft documents, you execute them formally. It forces everyone to properly engage, think about the implications.
Make sure they actually intend to create these legal rights.
Exactly. It encourages that careful thought.
So these formalities, they're doing double duty, as the question suggests. Protecting owners, protecting buyers, keeping the whole process sound.
Yeah, that's the idea.
But what happens when sticking rigidly to those rules just leads to a really unfair result? That's where equity comes in, right? With that famous phrase.
The equity looks to the intent rather than the form. Yeah, this is the crucial pivot. The law loves its forms for good reason, but equity sees that sometimes relying only on the form would be, well, wrong, unconscionable.
So it steps in to smooth the rough edges.
Precisely. It's there to prevent someone exploiting the strict letter of the law unfairly, especially if someone else has relied on a different understanding.
Now, our focus today, driven by the exam question, is proprietary estoppel. But it's not the only exception, is it? The question hints at things like constructive and resulting trusts. What's the common thread there? What principle do they share with estoppel?
They're all equitable tools, really. Ways the law deals with situations where the official legal ownership doesn't quite match the reality of contributions or promises or reliance.
Okay.
So constructive trusts often pop up with, say, cohabiting couples where there wasn't a formal agreement, but one person acted to their detriment based on a shared understanding about the house.
Right.
Resulting trusts might be about who actually paid for the property, even if their name isn't on the deed. But the core idea, linking all of them, including estoppel, is preventing one person from unfairly denying another person's interest in the land when the formalities aren't quite there, stopping unconscionable behavior.
Okay, so now we hit the really interesting bit, the absolute core of that 2024 exam question. Proprietary estoppel. It's meant to stop a legal owner going back on their word if someone else relied on it and, suffered because of it.
Sounds fair enough on the surface.
It does. But the exam question itself flags a big problem. It says the way it currently operates is not clearly defined. And that's where it gets messy.
Exactly. The principles stop people acting unconscionably, that's sound. But applying it, that's where the uncertainty the exam question highlights really bites.
Let's break down those uncertain elements. First, the promise or assurance itself. What actually counts as an assurance?
Yeah, what's clear enough?
The question implicitly brings this up by making us think about cases like Thorner v. Major, where, nods and winks and indirect stuff over years was enough.
Right, very implicit, based on conduct.
Versus Cobb v. Yeoman's Row, where there seemed to be a clearer commercial understanding, but it wasn't enough. What does that contrast tell us? How vague is too vague?
That Thorner and Cobb comparison is key. Thorner showed it doesn't have to be a formal, explicit promise. It was about the claimant reasonably understanding, over decades, from conduct and hints, that he'd get the farm. And he acted on it.
Based on the whole context.
Exactly. Context is crucial. Cobb, though, was different. Experienced business people negotiating. Even with an agreement in principle, the court said, look, you guys know you need a proper contract for this stuff. No estoppel.
So the type of relationship matters. Family versus business.
It seems to weigh heavily, yes. An assurance in a family or domestic setting might be viewed more flexibly than one between commercial parties who are expected to put things in writing. So too vague really depends on the facts, the relationship, the whole situation.
Okay. And then there's reliance. The exam question makes us ask, what does someone actually have to do to show they relied on the promise?
Reliance just means you changed your position because of the assurance. You acted differently than you otherwise would have.
How did that look in practice?
Well, in farming cases like Thorner, it could be working for years for very little money, expecting to inherit.
Giving up other opportunities.
Yes, or investing your own money in the property, maybe providing care for the person who made the promise. The key thing is the causal link. You did it because of the promise.
Got it. And detriment. Is that always about money? The exam question prompts us to think about that, too.
No, not just financial, though money often comes into it. Detriment is broader. It's any real disadvantage suffered because you relied on the assurance.
Like giving up a secure job.
Or spending years providing care, like you said. Or just personal hardship linked to the reliance. Pouring time and effort into improving a place you thought would be yours, it just has to be substantial enough that it would be genuinely unfair, unconscionable for the promiser to go back on their word now.
Right. But even if you tick all those boxes, assurance, reliance, detriment, you've proved your estoppel claim. What do you actually get? The exam question highlights this as discretionary, pointing to cases like Gillette v. Holt.
Where he got the property interest, yeah.
And Jennings v. Rice, where it was a monetary award instead. So what decides the remedy? Is it about giving you what you expected? Or just compensating the loss? Or something else?
And this is probably the most unpredictable part, just like the exam question suggests with its not clearly defined comment. The courts have huge discretion here.
This is not automatic.
Not at all. They might start by thinking about fulfilling the expectation, like in Gillette, but crucially, the remedy also has to be proportionate to the detriment suffered.
Proportionality.
Yes. Jennings v. Rice is the classic example. He expected the whole house, but the court felt that was way out of proportion to the actual detriment, his work and care. So they gave him a large sum of money, but not the house itself.
There's a balancing act.
A real balancing act. They look at expectation, detriment, the conduct of everyone involved, trying to find what's fair, what's equitable in this specific case. But that wide discretion, it definitely adds to the uncertainty.
And the exam question mentions that even the House of Lords, in Thorner, admitted estoppel, is very fact-specific. Now, that flexibility lets courts do justice in unique cases, sure. But what's the downside? Having such subjective rulings in property law. Does it damage that certainty we talked about earlier?
It absolutely does. That's the direct trade-off. If everything hinges on the unique facts, it becomes incredibly hard to predict outcomes for individuals, even for lawyers.
So more people might risk going to court.
Potentially, yes, because the lines are blurry. It also makes it hard for landowners to know where they stand if they've made informal comments or promises. It creates uncertainty, can slow down transactions, maybe increase costs. It's a big tension with the need for clear rules that the exam question flags as a weakness.
So bringing it back to that 2024 October Zone 8 question, there's this clear conflict, isn't there? The law needs its clear rules for land, for very good reasons.
Absolutely. Certainty is paramount.
But it also needs a way to stop those rules causing really unfair results when promises have been made and relied on. That's Estoppel's job.
It's meant to be the safety net.
But the way it works now, as the question suggests, maybe introduces too much uncertainty. Is the balance off?
That's precisely the critique the exam question points towards. Has the pendulum swung too far towards flexibility at the expense of the certainty property law needs? The intention behind estoppel is fair stop unconscionable acts. But the lack of clear definitions, the wide remedial discretion, it creates unpredictability, a real problem.
So wrapping this up, thinking about that 2024 exam question again,
Yeah.
you can absolutely see why the law insists on written rules for something as major as land.
Definitely need that structure.
But you can also see why we need something like proprietary estoppel, a safety valve for when promises are genuinely made, relied upon, even without perfect paperwork.
Yes, the need for some equitable intervention seems clear.
The real challenge, though, as we've kind of explored through the lens of this question, isn't if estoppel should exist, it's how it should work,
How do we refine it? Make it clearer, more predictable, more consistent?
without losing that core ability to step in and achieve justice in individual deserving cases where formality failed.
That's the million-dollar question, isn't it? The ongoing challenge in this area of law.
And that leaves a big question for you listening and studying this area. In a legal system that values clarity, contracts, certainty, where exactly do you draw the line for exceptions based on informal promises and fairness? Is it actually possible to have both rock-solid certainty and truly equitable outcomes in land law? Something to definitely keep thinking about as you continue your own explorations.